and I want to welcome all of you this Friday morning to attend this very important workshop on domestic violence and gun violence. Just a couple of housekeeping matters. We are going to have a substantive conversation after my brief speech. And during the presentation, please make sure that you are muted. Because we want to make sure that you could hear our speaker well, so make sure that you're muted. But at the end of the presentation, you will be able to unmute and ask questions to Julia, our speaker, later today. We'll leave about 10 to 15 minutes at the end so that you could ask questions and unmute yourself. You are welcome to have your camera on. I like to see your faces and your reactions, of course, but you are also free to turn off your camera and take care of yourself and, get something to drink if you have to, and stretch if you want to. We will send out, I think we may have already emailed you all of the written materials provided by Julia. If not,
we're going to at the end of this presentation.
So we'll be sending you all of the written materials after this presentation so that you have them. But like for now, we would love for you to just listen and take notes. I think that's a better way of learning we have found, but you will be receiving all kinds of documents and materials that you will find useful. And also we'll be sending you an evaluation form. We would love for you to fill it out so that we could continue to improve the content of the content of our work. And thank you, Martha. She already actually sent the link from Julia, which has a lot of the resources and materials that you're gonna find useful. So I think that's kind of all the housekeeping matters that I'm going to say. Now I want to move to our main presentation on domestic violence and firearms. And before I hand it over to Julia, the one thing I wanted to mention and share with you is that I don't know about you. Yesterday, the Parkland school shooting verdict came down, and it's just been very disturbing. And did you all hear about it? The jury verdict came out and they decided not to send him to death penalty. And it's been very controversial and very disturbing, and yet another mass shooting in America. And also, I met Julia, who's our main presenter today, right after the Sacramento shooting, I think, Julia. Was that the time, or did we meet a little earlier? But certainly I connected with Julia because there was a father who shot and killed his 3 children at a church during a supervised visit earlier this year. And again, it's like real tragedy. And I was really distraught over that incident because I used to practice family law. I did a lot of restraining orders. I felt that whenever I did a restraining order for my client, I was doing something really good. Yet, these incidents continue to happen, and I felt really helpless, and I could really relate to this case that happened, this tragedy that happened in Sacramento. So when I met with Julia, I really felt like she had a solution for me, at least something that I could learn about, I could do something about. So it was really important for us to bring Julia and her expertise in our space so that, we could prevent really horrific tragedies in our community. So this is really a very meaningful workshop for me to offer to all of you because, this really issue is, very personal to me. And I think, it probably, you all feel this also, very strongly in your heart. So with that, I'm going to hand it over to Julia.
Well, thank you so much. I appreciate the invitation and, of course, the relationship that we have between Giffords and specifically myself and the Family Justice Center Network, and am honored to present today at the Institute. So I have material that will cover about, I could certainly talk for the next 85 minutes, but I'm also very interested in any questions you have. So I plan to allow for time at the end to include your questions. We may not get to all of the different topics and questions we have. So just so you all know, I am available as a resource to your community and would be happy to talk with you about issues after this presentation as well. I am an attorney and a social worker. I also teach domestic violence law here in San Francisco on the unceded land of the Ramaytush Ohlone, where I am located and coming to you from. But make sure everybody is muted. That would be awesome. Thank you. I know I'm a co-host, but I'm not going to be able to do that. So thank you to the team at the office that sent out the link to materials. Those are the materials for the session, and the slides themselves will be in a PDF so that you will have those afterwards. But appreciate you taking notes and then checking out those materials as I reference them. I've been with Giffords Law Center to Prevent Gun Violence for a few years now, since 2018, where I started on a part-time fellowship basis to work on implementation of extreme risk protection orders, known in California as our gun violence restraining order, but with a heavy emphasis on restraining orders generally. One of the areas that I had worked on for many years at Judicial Council California, you may not know this, but California has the largest court system in the country, and by some estimates, the world. And we have several hundred people who work at the policymaking body for our state court system, which is the Judicial Council under Article 6 of the Constitution, the state constitution. And that's significant because under the Chief Justice's leadership, the Judicial Council has the ability to make laws, rules of court, Judicial Council forms that you may be familiar with. Those are all laws that don't go through the same legislative process as statutes. And so my role there was to do training with judicial officers, focusing heavily on domestic violence, family law, child custody, mediation, supervised visitation, a whole range of issues, and also to provide legal guidance and support to the courts generally, train court staff, and write policy. And around gun violence prevention, addressing all of the different firearm prohibitions, many of which I'm going to be covering today. The Law Center was actually founded in the mid-90s after a tragic mass shooting at 101 California, a law firm in downtown San Francisco. I knew somebody, an attorney, Jack Berman, who was killed during that tragedy. And Jack's family and other attorneys and other professionals got together and formed what eventually became sort of the lawyers for the gun violence prevention movement, and were quite successful in changing California law in this space. And then years later, when Gabby Giffords, former Congresswoman and gun violence survivor herself, and her husband, Mark Kelly, now Senator Kelly from Arizona, they formed their own organization working on gun violence prevention out of Washington, D.C. And then later our groups merged in about 2017 or so, 2016. So we became part of the National Giffords Organization, and that's why we are the Giffords Law Center to Prevent Gun Violence and are located in San Francisco. So that is our story, and I am honored to work with Gabby, who is incredibly inspiring in terms of how she has navigated her life. There is a wonderful documentary out, Gabby Giffords Won't Back Down, if you have a chance to see it. It's by the same filmmakers who also made the most recent documentary about Julia Child and also about Ruth Bader Ginsburg. And, similar to these other iconic women, Gabby, I think, and her husband, Mark, have much to teach us about persevering in light of the kinds of things that we see. Raleigh, the mass shooting yesterday by a 15-year-old, it appears, and also verdicts and situations like Parkland. And of course, the everyday kind of ways that gun violence shows up in our community. So I should also note that at Giffords, we work closely with gun owners. Gabby is a gun owner herself. Gun owners are a part of our coalition, but we are also very concerned, of course, about the availability of firearms in our country. Firearm ownership is prevalent. It has increased during the pandemic. I use this statistic just to provide some kind of visual information for folks about how many firearms are out there in the hands of private citizens. While most we can believe, and we certainly see that most gun owners are responsible and also support common sense gun laws that support reducing risk and increasing safety, we know that the prevalence of gun ownership, certainly for people who may be first-time gun owners with limited training and experience, and the presence of firearms when domestic violence is an issue and other crises are occurring in a family, pose incredible risks of lethality, serious injury, and the possibility of coercive control combined with access to firearms can be incredibly dangerous for the people that we work with in courts, in social service agencies, family justice centers, and in all the work you do. So we have to recognize how common gun ownership is. This isn't something you may or may not be a gun owner on the call today, and you may not be in a community in which you can understand or relate to gun ownership, but you are likely working with people who own guns, who have access to firearms. The gun lobby, gun industry lobby has been very successful at convincing people that it increases their safety, quite contrary to the research. And in fact, domestic violence survivors have been a focus of marketing these days for the gun industry lobby that really needs to be selling and marketing firearms to as many people as possible. Similar to the cigarette industry in terms of creating a new generation and a younger generation that would believe that firearms increase their safety, there is also a focus on women as gun owners to serve as protection. So you are likely working with people who are either gun owners themselves or have access to firearms because someone else in their lives and in the house might own firearms. We also know that there are gender differences in understanding the availability of firearms, that often women are not aware of how many firearms their male partner might be purchasing or maintaining in the home. So we'll talk a little bit about how to handle that reality. But in California here, across the counties, I have statistics that I sometimes show depending on the presentation I'm doing about how many firearms are in Marin County, one of the wealthiest counties in the United States. This crosses class, race, geography, while it disproportionately, gun violence impacts our communities of color and communities where there may be fewer resources available for safety planning and for protection in the community. So lack of trust and confidence also in our government systems and law enforcement contribute to the complexity of this issue as well. And when we talk about gun violence, we're talking at Giffords and other organizations that work on gun violence prevention. We're talking about suicide, which is the most significant way that firearms are used to that result in lethal outcomes. Mass shootings, for example, represent around 1% of the homicides associated with firearms, but get the most attention in terms of the media. And we know that 2/3 of mass shootings have some connection to domestic violence. So I'll be talking about that as well. But we're also talking about unintentional killings, homicides that are occurring too often disproportionately in our communities of color. And we're talking about homicides associated with domestic violence and police shootings as well. So gun violence encompasses a really diverse set of issues, and there are various interventions and prevention efforts and responses to these varying types of violence that are necessary to really tackle the issue. Today, we're going to be focusing on domestic violence, but I don't want to contribute to the siloing of the issue insofar as we know that suicide, threats of suicide, and unintentional shootings, youth suicide and unintentional shootings by youth in homes can also be connected at times to chaos, crisis, trauma that's occurring in a home where domestic violence is being perpetrated. So we know that there are, too many lethal outcomes associated with firearms. And I'm going to just include some statistics here so you have a sense of the landscape. We know that there are an increasing number of cases in which firearms are used to coerce and threaten survivors or victims of domestic violence as well. It's part and parcel of the domestic violence experience. We also know that we're not always talking about lethal outcomes, that 4.5 million women have been threatened with a gun by an intimate partner. There's over 1 million women alive today who have been shot or shot at by an intimate partner as well. We also know that this affects people in different situations differently, that there's racial disparities in the experience of domestic violence. We were just going over a report that our office did on Alaskan Native and American Indian women and their experience of homicide around firearms, which is disproportionately impacting those communities as well as African American or Black women in our country. So we all may be experiencing gun violence in a variety of ways, but we don't all experience it the same way, or we're not at the same level of risk. Dating partners also represent a significant population in terms of at-risk folks. And those are women who are in dating relationships, never married situation. Of course, Jackie Campbell's research tells us that there are a combination of factors that can lead to particularly lethal or dangerous situations, 20 factors in particular associated with the dangerousness assessment work that she's done. One of them is there a firearm? Another is if there are children not of the marriage, for example, or not of the relationship. So there are all sorts of factors that can increase risks, but certainly the presence of a firearm and threats associated with that firearm, we have to take those seriously. The National Domestic Violence Hotline a couple of years ago reported on the increased number of calls that they've received where firearms are described. So at the national level, we're looking at least when those numbers came in, an increase of 19%, where folks who were contacting the hotline for assistance described being threatened with firearms. And some of that information we don't always get good access to if we don't ask the right questions. This isn't always something that's revealed clearly in our work with clients or litigants or patients, again, depending on what role you might be playing. I should also note, and I generally mention this at the outset of my presentations, but I recognize that in a group this size, or even any size, I teach a seminar course that sometimes has 10 or 15 students. In any presentation I do, I consistently recognize and hear about the fact that many of us who are participating in this call have experienced domestic violence or have been close to someone who's experienced domestic violence. So this is a particularly personal and often painful issue for all of us. We also know through Garen Wintonmute's research in California that many of us have had an EV, an exposure to violence, specifically gun violence, knowing someone in our community, walking past memorials to people who have died as a result of gun violence, losing family members through suicide. So this is both I approach this as thinking about what you can do as a professional, but I also think we bring our full selves to this work. And so exploring how this is all impacting you personally, I think is also really important. So when a woman dies as a result of domestic violence, it is most likely that that's going to be as a result of a firearm. It's far outnumbers other types of lethal means in domestic violence homicides. One of the statistics I've already mentioned, and I want to further examine or share with you, is this research that's been done that indicates that over 2/3 of mass shootings have some connection to domestic violence. And that looks different in all of the different mass shootings that this pertains to. Sometimes it's the case, like in the Pulse shooting in Orlando, where there was a history of domestic violence, and perpetrated against that shooter's relationship, intimate partner. And you can see here in this headline that he's mentioned, and it's pointed out that there was no record of previous hate crime. But that depends, of course, on how you define domestic violence, which many of us would define as including hate, misogyny, gender-based hate, or other forms of hate that are associated with intimate partner relationships. We also know it shows up in most recently in the Uvalde shooting. There was a history of threats against teenage girls online. Of course, a family member was harmed in that shooting as well. So sometimes it's not just intimate partners, but also other relatives and family members who are impacted by an individual's violence. And then another way, and these are not the only ways it shows up, but another way that this is relevant is that we have situations where somebody has a restraining order, a domestic violence restraining order issued against them, or they have a previous conviction for domestic violence, both of which prohibits your access to firearms. And we're going to go more into detail around the legal requirements or prohibitions in this area. But under federal law, which means that applies to all of the states, if the conviction meets the definition of domestic violence, you are prohibited for life from having a firearm. And how does that actually work in real life? That means the conviction is issued. It is supposed to be entered into the database, the National Criminal Database. And when you go to try to buy a firearm from a licensed gun dealer, if they run a background check, then the background check will reveal that you are what's called a prohibited person. And so in the case of Sutherland Springs in Texas, the church shooting, that individual had been prohibited as a result of a restraining order that the military had issued, the military was aware of, and that the military was responsible for putting into the database. They failed to do that, and that individual was able to purchase a firearm from a otherwise legal source because the prohibition did not come up because it had never been entered. So we also know there are so-called prohibited people who have been found to have perpetrated domestic violence. Our policy nationally, bipartisan, says you can't have a firearm if you meet that definition. But if we don't implement those prohibitions effectively, then they can get a gun and commit the kind of heinous act that was committed against the church in Sutherland Springs. So the good news is we can do something about this. So, that's all very heavy information, incredibly painful to know that we live in a very violent country. These are particularly, they're not unique to the United States. We certainly hear about mass shootings in other parts of the world, but the prevalence of gun ownership, private gun ownership, and the amount of gun violence is unique to the United States. So I think recognizing the level of violence is critical, getting a sense of the landscape, but also knowing there are things we can do about this. This is not just inevitable. And many of you are in a position where you can, on an individual basis, in your professional capacity, work with people to decrease risk. And we can also do things at the policy level. And a lot of us are involved with that. So one of my favorite statistics that is supported by good research is that we see a 16% reduction in homicides associated with domestic violence when we have procedures in place to ensure that someone who shouldn't have a firearm, in those domestic violence cases I described, civil restraining order matters or convictions for domestic violence, in those cases where we have procedures in place to ensure that folks who currently own firearms no longer have access to those firearms, relinquishment procedures, as they're generally referred to, sometimes as surrender procedures, but where you're required to turn in your firearms, we see a 16% reduction in homicides. So that's just one example, but I want to really emphasize that law and procedures make a difference. And the reason I'm implementation director is because that was a position that was created for me because of the years I spent working on policy and recognizing that we can develop good policy. They're advocates for decades who have been working on good policy, but if we don't actually implement the laws, we're not going to realize the promise of these good policies. So I wanted to highlight that in California, we have many years of working on developing policy. I was honored to be a part of a team that responded to then Attorney General Bill Lockyer's work called Keeping the Promise. So he was Attorney General back in 2005. He asked for a report on how the courts were handling domestic violence cases, how law enforcement was handling domestic violence. And that was a report called Keeping the Promise, which ended up being a scathing report about how both law enforcement and the courts were addressing domestic violence cases, with a particular emphasis on what was going wrong with respect to firearms policy. So, for example, we had judges who were crossing out prohibitions on the form because they felt that just because someone had been violent didn't mean that they shouldn't have access to their guns. And the Attorney General developed a form letter that went to judges who had done such a thing to say, guess what? If you do that, your order doesn't make any sense. We can't enter it into the database. It can't be enforced. And you've just wasted a lot of your time. It was more politic than that, I would say. But basically, that's what Attorney General Lockyer was communicating to the courts. That was one problem. Service was a very serious problem. Law enforcement not serving orders. And again, those are examples of implementation. If you issue an order, but nobody knows about it, there's no service of the order, the prohibition against firearms is not effective until it is served. So in response, the then Chief Justice of the California Supreme Court, Justice Ron George, formed the Domestic Violence Practice and Procedure Task Force, which was the group that I was part of, along with some other really key staff and members of the judiciary and others from around the state, including domestic violence victim advocates. And this report was issued calling for recommendations for improving how we handle domestic violence and firearms cases in the civil and criminal legal context. I'd like to just point out here that the report came out in 2008. So this was 2005, 2008, and just to remind everyone, we're in 2022. So this is not new. That report included recommendations that were, many of which were adopted, that changed policy in California. I would take us back to one of the first classes I taught in the mid-90s at Washington University in St. Louis was called Race, Gender, and Law and Violence Against Women, that I developed in response to the O.J. Simpson case, where Nicole Brown's homicide was, he was charged with her homicide, and we all know what happened after that. But that whole process—
oh my God, I'm in a freaking freak out.
Again, please, let's make sure everyone's muted. That would be great. Thank you. Anyway, that resulted in some really significant changes in California's approach to domestic violence. So we've seen over the last almost 3 decades now, significant changes in our approach to domestic violence in California. We have a variety of ways that people become prohibited. This is one of the things I think is really important to highlight. There's a lot of misinformation out there, and I'll be covering some of that today, around firearms and the Second Amendment and whether we can prevent people from having guns at all. So I want to just really emphasize that this is a handout, a document that actually is not in the link you got, but I can add it to that, that describes all of the different ways that people can become prohibited in California under California state law, but also under federal law. And it's a multi-page document. you become prohibited for all sorts of reasons, in the civil context and in the criminal context. And so the Department of Justice puts this out so that lawyers and probation and judges and others can have law enforcement can have an easy to reference guide about the statutory framework for prohibitions across the board. And I raise this again because too often I think we believe that there's only one way or a couple of ways to prohibit someone. We have actually, since early on in this country, regulated who has access to firearms in a variety of ways. Some of that was based largely on white supremacy in the early days of this country, with the notion of who we were thinking of as dangerous, and regulating access to firearms for enslaved people, and for even free Blacks in this country as well. So I would also encourage you to read The Second, which is a book by Carol Anderson that goes into the historic regulation of firearms in this country, and also our approach to addressing gun violence and how deeply connected it is to race and structural racism as well. But sort of moving forward to today, these regulations cover a range of issues where we have an understanding of often the nexus between some behavior, as opposed to people who are dangerous, but some behaviors that indicate dangerousness, and access to firearms. So when we're talking about domestic violence, that's really the nexus. This isn't just another way to punish people, but really is, again, going back to the statistics, recognizing that it is a potentially lethal combination. When someone is perpetrating violence, whether it's physical abuse or not, exerting power and control in an intimate partner situation, and has access to a firearm. Similarly, when there are certain crisis situations where someone's mental health may be at issue, where suicidal ideation may be of concern, that's a high risk. We also believe that when people's brains aren't fully developed, young people, there are risks associated with easy access to these incredibly lethal and powerful firearms. So just so you know, lots of different ways to become prohibited, and I'm only going to cover some of them. Now, I am a lawyer and a social worker. I did a combined degree. This is a presentation that is largely focused on legal remedies. There are other remedies, and there are lots of reasons why people may not feel comfortable navigating the legal system. For those of us who do work in the legal system or have worked in the legal system, I think we sometimes forget how stressful and frightening the court can be. We did research based on experiences around gender bias and racial bias in the California courts. And a lot of the input we got from individuals who are navigating our courts included just the experience of going through security, for example, in a courthouse, and how intimidating that was, and how much bias people felt as though they experienced going through just the initial part of showing up at court. And then you go to the courtroom, and even if one of the stories I share often is of a judge who had worked really hard to create a courtroom environment that was a little less formal, more accessible, very compassionate, trauma-informed, the language that she used, the way she approached her cases, the respectful way she interacted with the parties. She had worked really hard on that. And one day she happened to hear her bailiff, who opened the courtroom for folks before she took the bench. And she realized that the way the bailiff was treating people who came into the courtroom was completely contrary to everything that she had been working on. So by the time she was taking the bench and trying to do this trauma-informed court procedure work, the atmosphere had already been tainted by the way this particular individual was treating people coming into the courtroom. And we've all seen the signs, no gum, no kids. What are you supposed to do with your kids if you're going to court in the middle of the day? We know that there's a lot of stress for people navigating the court process, And hopefully you have some sense, if you work in the court process, of what you need to do to take care of yourself to deal with the vicarious trauma that many of us who work in the court system experience, just with the accumulation of the years of stories and painful situations. So I'm going to be emphasizing legal remedies and legal policy around domestic violence and firearms today. But we know that there are safety planning efforts, there are procedures for voluntary relinquishment, and that there are other ways of developing responses and remedies that don't rely entirely on going through the court process. Certainly, these are available tools that I think people should be aware of and should be considered as part of safety planning, but not everybody needs or wants a restraining order, and not everybody needs or wants to pursue law enforcement, conviction, prosecution, and so forth. Even when it comes to gun violence. So what are some of those tools in California? That's what I'd like to focus on at this point, so that we all have an understanding of how domestic violence and firearms are handled in our state. So one of the primary ways is a domestic violence restraining order. The first restraining order, a domestic violence restraining order that ever existed in the country, was actually in Pennsylvania in 1976. And so while that's some time ago, it isn't that long ago. It was a radical idea that someone, without relying on a district attorney, a prosecutor, the state, could go directly to the court on their own or with an attorney and ask for an order ex parte, without the other party, and that would restrain that other party's behavior, might require that they give up property like their house, not have contact with their children, because the requesting party was so concerned about violence. This was a radical notion in our country, because you generally can't have any kind of court order without the other side being allowed to know about it and be allowed to present. That's due process. Due process, that phrase means notice and the opportunity to be heard. And so the idea that courts would be able to do this to people who may not have done what they're accused of doing was very controversial. It has consistently been upheld because, one, that kind of ex parte order is temporary. You have an opportunity, usually within 2 weeks or so, to go in and say, that wasn't me, I didn't do it, and I shouldn't be restrained. But also because domestic violence is so dangerous, and that there's a need for immediate protection, and that we're willing to take that risk for a short period of time to address domestic violence. So domestic violence restraining orders were first of its kind, really, based on some older legal understanding of what are referred to as injunctions, civil orders. They were also new in the sense that you didn't have to decide to get divorced. You didn't have to prove what you used to have to prove in order to divorce or separate. You could go in and say, I don't know if we're going to divorce or separate, but I can tell you I want the violence to stop, and I may want this person to stay away from me. Even stay away or no contact orders aren't necessarily included in all domestic violence orders. What most survivors at the very least want is for the violence to stop, and they may want other kinds of remedies that I'll get to in a bit. We also, in California, we have the most expansive number of tools available to us in the civil context for restraining behavior when there's concern about someone being a danger. So elder abuse orders, again, can be used in domestic violence cases, but also used in cases where you're concerned about financial abuse, for example. They are firearm prohibiting orders when they address domestic violence. Civil harassment orders, where you don't have to have the intimate partner or family relationship, strangers, neighbors, stalking, some stalking situations, sexual assault, rape cases where someone is engaging in ongoing contact, harassment, and other forms of abuse. So civil harassment orders, firearm prohibiting. Workplace violence prevention orders for employers where there is an employee who is coming onto the property, threatening, abusing, harassing other employees, or creating problems at the workplace that are dangerous enough to be restrained, firearm prohibiting. Then we also have school violence prevention orders, similarly firearm prohibiting for private post-secondary college campuses to restrain parties, firearm prohibiting. And then in 2016, we were the first state to adopt a statutory framework called the Gun Violence Restraining Order, or GVRO. The GVRO is firearm prohibiting, just as all these other orders are, but that's the only thing that the GVRO does. It is designed to address situations where there isn't the kind of relationship or a history of abuse or threats against an individual. The GVRO is distinguished from these others because there is no named protected party and there are no other remedies. All the other firearm prohibiting civil orders include additional remedies to address the threats and abuse and so forth. GVROs were largely thought of as suicide prevention and mass shooting threat, generalized mass shooting threat prevention tools. And at this point in California, you can be a petitioner if to request a GVRO if you are a law enforcement, household member, employer, school administrator. And 96% of them have been petitioned for or requested by law enforcement. So it's largely been an expansion of law enforcement powers in the civil context and largely used to address mass shooting threats, again, where there isn't an individual or a family or household member who needs protection. So we also, in the criminal context, have ways that people become prohibited. When someone is arrested and charged with a domestic violence crime, pending the trial, the court can issue a criminal protective order, or a CPO. Those are designed to protect witnesses and to protect identifiable victims. So someone may be prohibited from contacting a victim of domestic violence and other household members in a criminal context, even prior to being convicted or going through a hearing. And those are firearm prohibiting if they are issued on the Judicial Council form. So there are very specific procedures there that are critical as part of ensuring that a firearm prohibition is in effect. You may also become prohibited as a result of a conviction, a felony conviction or a misdemeanor conviction. And we have very specific processes in California where probation, if you're on probation, is required to look up whether or not you own any registered firearms, which is something we can do in California because we have the automated firearm system, AFS, where if people have firearms and have appropriately registered them, which is what's legally required, then we can identify them as an armed person, as someone who owns firearms. When you become prohibited, you also go into the prohibited person system. This is all in CLETS, the California Law Enforcement Telecommunication System. When you become prohibited and you also are in AFS, known as a person who owns firearms, there's a system called APPS, the Armed Prohibited Person System, that will, those systems ping each other every day and then spit out a list of people who are armed and prohibited. Now, of course, this relies on people appropriately registering their firearms, and it relies on the courts and law enforcement appropriately entering those prohibitions. We have 23,000 people in the APPS database in California, which means that we know that these people are armed and we know they're prohibited. So there is extensive work done across the state. Most recently, we saw an example in Orange County of an individual who was prohibited as a result of a domestic violence conviction, was known to have firearms, was in the APP system. And the APPS team, which is a team of people who are trained to address these longstanding firearm owners who are prohibited, who have refused to comply or have not been able to comply for any number of reasons. When they tried to serve that person with a warrant or tried to address the issue, he opened fire on the police officers at the scene. One of the areas that we work really hard on is addressing how to ensure that that prohibition is effectuated, is implemented as close to the time of prohibition as possible, not waiting until somebody ends up in the armed prohibited person system. And so I'll be covering that as well. So we also know people can become prohibited as a result of being admitted and evaluated through a mental health institution. So sometimes referred to as a 5150 for shorthand, but it actually requires a little bit more than that because you have to be admitted and evaluated. So there are mental health prohibitions as well. We maintain an extensive sort of encyclopedic approach to gun laws across the country. So you can check out our website to learn more if you're looking at, what are the gun laws in Nevada, or I want to know more about California. You can check out giffords.org, and there's a lot more information there. One of the things you'll have in your materials, if you haven't taken a look yet, but you will see this there, is a chart that I've created that tries to provide information in a very accessible way about how all of these different restraining orders are similar and different. So you'll see all of the different requirements or characteristics listed there. It's front and back. It only addresses the civil side of things, but if you're doing safety planning with folks, I think it's critical to be aware of all of the different requirements and the limitations and remedies that are associated with each of these remedies or these legal issues. Because this is a domestic violence lecture today, and hopefully a little bit of a conversation, if you have some questions that I can get to in a bit, I wanted to really highlight specifically the why of domestic violence and firearm prohibitions, and why domestic violence restraining orders are different and really important. This is not to say every domestic violence case should have a restraining order. That is a part of a safety plan that people should be able to engage in confidentially with someone trained in the field. But we don't often recognize how robust, how rich our domestic violence restraining orders are. One thing I want to point out is that they are civil orders. They are civil orders because historically, law enforcement and our criminal legal system was not always responsive to complaints about domestic violence, or were at least inconsistent. Sometimes there was over-policing and prosecution in some communities and under-policing and little prosecution in others. We knew in the movement that there was a need for direct access to the courts. I don't always want my partner to end up in jail or be arrested. I just want the abuse to stop, for example. And I need that to happen in a way that will still give me access to the things that are preventing me from being able to have the autonomy that I need. That could be something a survivor would share. So they are civil court orders, which is really important. They respect and rely a lot on survivor autonomy and control and decision-making about when to pursue them. They can protect an individual and household members. They can say this person needs to stop abusing, threatening, or coming near me and the people in my family, in my household. Not every order can do that. For example, the gun violence restraining order cannot do that. They can say you can't come to these particular locations. They say you can't physically abuse people, molest, disturb the peace, threaten, and so forth. These orders say you can't contact people. They can, they're not required to, which is really important too. These are boxes that you can check, and you can say, I want the abuse to stop, but I'm okay with having contact because we're going to be exchanging the children, for example, or I'm not ready to separate entirely, but I want the abuse to stop and I want there to be consequences if it doesn't. No phone contact can be ordered. You can get a move out order. You can require that someone go to a batter intervention program, the restrained party. You can protect pets, which again wasn't always in place, but a really important remedy that sometimes people don't leave because they're afraid of what's going to happen to their pets or their animals on their farm. And we need to say those are going to be protected as well. You can be given permission to record conversations that otherwise would be illegal to record because you are gathering information about the abuse and because knowing that someone's being recorded might actually reduce the violence. You can get child custody orders, having a very specific plan for no visitation, supervised visits, or joint legal and physical contact, if that's what makes sense. You can order someone to pay bills and attorney's fees. And all of these orders, they are discretionary. The one that isn't is no guns and ammunition. Those are automatically applied at the EPO, emergency protective stage, at the TRO, temporary restraining order stage, and the order after hearing. The only exception is if you are a peace officer or someone who needs their firearm for employment, and then there's a very specific process you have to go through to get permission to maintain those firearms. So it's critical for folks to understand that, especially right now in California, because there's a national conversation about the benefits of red flag laws, as they're often referred to, extreme risk protection orders, which is our GVRO. In some states, those remedies are not as readily available or don't include the same kind of prohibitions around firearms. So ERPOs, extreme risk protection orders, are a resource for some domestic violence survivors. In California, that generally makes very little sense. And there's a lot of misinformation out there that I wanted to cover today. We know that survivors are at higher risk when they pursue restraining orders, because one of the rules in a domestic violence situation is generally you may not leave, you may not tell anyone, and you must be loyal. You are violating all of those rules when you go to court and seek a restraining order. You are talking about the relationship, you are not being loyal, and you are often trying to separate. So it's a very dangerous time. Separation violence is very real, and we have to recognize that requiring people to go to court multiple times or at all is very dangerous. So we have to be careful. I've already mentioned what GVROs were intended for. So be very careful if you start to see information out there that suggests that they are intended to protect survivors. That is not true. They were intended to address suicide threats and mass shooting threats. There is no named protected party in a GVRO case. The DVRO covers the exact same requirements as the GVRO with respect to firearm prohibitions and ammunition prohibitions. GVROs also will not provide any basis for custody and visitation. And by that, I mean, this isn't a presentation on Family Code Section 3044 or any of the custody issues on DV and firearms, but we have very good law that says if somebody continues to maintain a firearm in a domestic violence situation, that needs to be considered when looking at how safe custody and visitation might be for that person. If the order is a gun violence restraining order and not a domestic violence order, the court is not going to have that same basis for being concerned about custody and visitation because there's no connection to domestic violence. So that's a tricky legal area, but important to recognize. And I can't emphasize this enough. The GVRO is the only civil restraining order that doesn't name a protected party. It just restrains someone. Incredibly important. We have lots of cases where someone needs to be prevented from having access to a firearm or ammunition, and there may not be a criminal charge that goes along with it. They may not be eligible to be admitted and evaluated in a mental health facility. And it's critical that we remove those firearms and put them into a system where they couldn't purchase a firearm. So the GVRO is an incredibly important tool, but it is not one that addresses all of those other issues that come up in domestic violence. And they don't include naming any protected party individually because they're generalized threats or threats of harm that that person might do harm to themselves. Under federal law, we have additional prohibitions on firearm access and restraining orders, but we don't have those for GVROs. So those only exist for domestic violence restraining orders. We also have extensive relinquishment requirements and consequences for not following through on giving up your firearm, and I'll talk about that under SB 320 next. And we know that having multiple, asking people to go to court twice is not a good idea. So once in a while, I hear someone say, well, what's the harm in telling a survivor that they should get a domestic violence restraining order and they should also get a GVRO? There is enormous potential for harm. It shouldn't be necessary because the order will be firearm prohibiting, the DVRO, and you're asking them to make multiple court appearances, ensure that the other party is served, and provoking that person around additional restraints. So we have to be really careful and thoughtful about that. And I encourage you to be aware of that, especially given how the media consistently covers the need to be aware of and utilize gun violence restraining orders. It's my position that we need to do a better job utilizing the firearm prohibitions that exist in the domestic violence context when we're talking about domestic violence. And that's really what implementation is all about. So one of the challenges we've had is going back to that reference I made to keeping the promise in 2005 and the domestic violence task force report from 2008 is that, again, it's 2022 and we're still seeing too many tragedies associated with firearms and domestic violence. So the case here that was covered by Cal Matters, they did a very extensive investigation. Robert Lewis was the journalist. This came out last year, two-part series. It really focuses on the problem generally of lack of implementation of our firearm prohibitions in California in the domestic violence context, but highlights the story of Callie Garay, who was a 32-year-old mother of three young boys who went to the court, provided a 12-page affidavit declaration in her request for a restraining order about the extensive domestic violence that she was experienced, about specific threats related to her partner's access to firearms, threats to kill her, and there was the firearm prohibition should have been included, was included, but the judge from the bench said, you are prohibited, but I don't see any evidence here that firearms are of any concern, so I'm not too worried about it, basically, and issued the restraining order. Just that kind of dialogue, de-emphasizing the seriousness of the firearms in the case, basically admitting that the 12 pages had not been read by the judge, was incredibly upsetting, reflects a very serious problem, at least with that particular judge, and one that we teach on, certainly before and now ever since, how important it is for judges to understand the intricacies of the cases that are before them, even on impacted calendars, because just not too long after she was shot and killed by her ex in front of her children. One of the things that also came out in the investigation is how often firearms are described in restraining order cases, that people are ordered to no longer have their firearms, and that out of 20 cases that were looked at in one superior court, only one of those cases had any evidence that the person had actually complied by turning in their firearms. So there were cases where the court knew firearms were part of the issue, the court issued the order, and even though the person was prohibited, that information did not show up in the file. So we worked hard along with Senator Eggman, who was the lead author on SB 320, to change the way things are in this area are handled in California. SB 320 became effective January 1st of this year. It is largely based on pre-existing law that was in the form of those rules of court I mentioned at the outset. The Judicial Council, as part of the report from 2008, had adopted rules of court that apply in all 58 counties that said courts have to take firearms seriously in domestic violence criminal cases and in domestic violence restraining order civil cases. And that includes, in the criminal context, mandatory review hearings to ensure that someone who has firearms and is convicted has turned those firearms in. That has largely been implemented in a variety of ways. In the civil context, it said they should have compliance or review hearings, or other methods of ensuring that these firearm prohibitions have been complied with. But as the Cal Matters report indicated, we know that wasn't happening. So we decided, and I say we because Giffords was the sponsor of this bill that Senator Eggman led on. We said we need some statutory language on this. So we took that law and we worked with her office and the legislature on turning it into a set of statutes. That means when we say we took Rule 5.495 and turned it into a statute, that includes Family Code section 6322.5, but it also amended some other code sections, including child custody sections like 3044 and also 6389, which addresses actually how you relinquish, and 6306. So I'm going to highlight some of those. You don't have to memorize all these numbers. I know not everyone is a legal nerd or attorney on this call, both of which are monikers I proudly provide myself. But I'll just say that these are policies and procedures that hopefully you'll see some of yourself in and basically understand in terms of the work you do. What hasn't changed is law enforcement is still required and has been required in California for some time to have protocols for removing firearms at domestic violence scenes or when they're serving orders. The prohibition is effective when it is served, when the person knows you are hereby prohibited. That's when it goes into effect. And again, what hasn't changed is the court must still consider firearms and information about firearms in the cases where it comes up in domestic violence matters. We know that under 6389 now, and again, this has been, most of this has been law for some time, that when the order is issued, the court shall, no discretion, they're ordering relinquishment of any firearm or ammunition that the restrained person has. And at the scene or at service, the law enforcement officer must remove firearms that are in any kind of plain sight. So if you see firearms and you're serving a restraining order, you're required to remove those, or that are found through a consensual search, which means if someone says, well, come on in, officer, not a problem, and you have consent to search, you have to remove those firearms. Whenever an officer says, you're hereby ordered to give me your firearms, you are required to relinquish those firearms. If the firearms are not relinquished at service or at the time that they are demanded to be turned over at the scene, then when the person gets notice, they have 24 hours to relinquish their firearms. And they have 48 hours, so another 24 hours after that, 48 hours from the time of service to provide proof to the court and to law enforcement that they have complied. So that means submitting a piece of paper, a receipt. A DV 800 is the piece of paper that the Judicial Council form is numbered that makes it easy for you to turn in proof that you have complied. So every restraining order file where there's any indication that someone currently owns a firearm, whether that firearm is registered or is unserialized, ghost gun, illegally possessed, they are required to turn that in within 24 hours and provide proof to the court within 48 hours that that has been accomplished. Now, one of the things that we did change is that we want to make sure we are as fair as possible and that everybody who is prohibited knows they are prohibited and knows how to comply. We do not want people to unnecessarily be exposed to criminal sanctions, which can happen. It is a crime to not comply with a restraining order. So we wrote into the law that courts are required to tell people how they can comply locally. We know that law enforcement is supposed to have policies about how to handle people who want to relinquish. There is a form, statewide form, available at courts.ca.gov that tells people all about how you can comply. This form, DV-800 info, also available as the JV or juvenile form. Same kind of form is available in civil harassment, elder abuse, and GVROs, and other firearm prohibiting civil restraining orders. It tells you exactly how to comply, but it's general because it even mentions the yellow pages, which a lot of us don't even know what the yellow pages are. So that's not that useful in terms of local requirements. So this is an example of Santa Clara's form. Santa Clara did the work to say, okay, person, you are prohibited. Here are the phone numbers in our county of law enforcement agencies. Call them up. I'm bringing my 20 firearms over. They are unloaded and locked in my trunk. Is that adequate? Because you don't just walk into a law enforcement agency with your cache of firearms. That can be very risky for everybody involved. So you should be in a county that has this in place. Again, this was required as of January 1st. If you don't have it and you want to find out what's going on, and you don't work at the court, talk to your court, talk to your family justice center, talk with your local family violence council, coordinating council, or reach out to me and we'll find out what's going on because we want everybody to have this. When the courts are required to run a 6306 check, it's called under Family Code Section 6306, to find out if this person has firearms, because they can look in the automated firearms system to find out. That's another source of information. You have the declaration, you have the research that the court is required to do. And when they determine that someone has or does not have firearms, they need to put that on the record. Again, that's significant for legal purposes. And I just want to highlight that. The court may decide to have a review hearing. They don't have to, but they must review the file to make sure that somebody complied. I think the easiest way to do that is with a compliance hearing, but if you want to assign a clerk to do that, you can do that as well. So some of what I do is work with courts on what's the best way for them to move forward with these requirements. When there's a violation, they are required, the court is required to report that violation to the prosecuting agency and to law enforcement, and law enforcement's required to take immediate action. This is a significant difference from before. We are trying to take the burden off of victims or protected parties and put it on the court system and law enforcement and prosecutors to actually make restraining orders in the domestic violence context even more meaningful. This is unique to the domestic violence restraining order, that when there's a violation, when you get on Facebook and you find out your ex still has a firearm and is taking pictures of themselves, and you don't know what to do, there needs to be mechanisms to report that violation to the court, to get back in front of the court, or if the court finds that the person hasn't turned in their firearm, they are then required to make that report. So still maybe some work on a protected party's part, but ideally we have a court, when they haven't complied, certainly within that 48-hour period, making the appropriate report, and that prosecutors and law enforcement are taking that very seriously, because we want to prevent having a long period of time where somebody who's not supposed to have a firearm has a firearm, because that increases risk for that protected individual and for the community at large, especially, again, given 2/3 of mass shootings have some connection to domestic violence. We all want red flags. What are the red flags for mass shootings? Domestic violence is a big one. So it also must be considered if there's a violation in the custody matters. It can be charged as a separate crime. There can also be civil contempt charges brought. There can be monetary sanctions and fines associated with a violation. So there are a host of consequences for a firearm prohibiting person who violates a domestic violence restraining order. Another reason why this is a more protective approach. Courts are developing forms for this, forms that are referred to as these findings regarding non-compliance with orders to issue, to relinquish your firearms. So in your jurisdiction, you may start seeing these. They, again, should have been in place by January 1st. The Judicial Council will have statewide forms available, hopefully in the next few months. If you have questions about that, let me know. They are similar to some of the findings that have been in place for a long time in the criminal context. So this is the criminal version of that form, which is just important to understand that, again, some of this is new in terms of requirements, but not new in terms of procedures. All right, so what else can we do in this last couple of minutes? You can have courageous conversations about firearms. Figure out what it is you can ask and what kind of information you can provide. One of the other handouts I provided in your link to materials is a set of questions that I'm not suggesting you ask all of them, but to give you some kind of a script about, better questions to ask. For example, do you have firearms in the home? May not be as useful as, do you feel comfortable talking to me about firearms that are available in your home? Because not everyone may be comfortable revealing that. Do you have information? Could it be that your partner has firearms you don't know about? Having those kinds of conversations. And before you're asking the questions, pushing information out about why you're asking those questions. People have firearms because that's how they get their dinner. They hunt. People have firearms because they are security officers and police officers. They need them for their job. This isn't about eliminating all firearms for everyone in all situations, but making the connection between risks associated with domestic violence and firearms. Understand the available remedies, understand how important safety planning is, and engage in safety planning with that in mind. Keep in mind that you might be in a situation where no visitation is the best option. And, just as we're doing this kind of connecting today, virtually, that can be a possibility in child custody situations as well. Virtual visitation, where supervised visitation may not be safe. We tragically lost the 3 girls who were murdered by their father in Sacramento earlier this year, as Suzanne mentioned at the start of this presentation. And there are many other tragedies. I've worked with way too many mothers who have survived situations where their children have been murdered in a situation that should have or was thought to be a supervised visitation setting. This is a very real and serious problem. So we have to do more safety planning around visitation and exchanges. And I'd like you to be thinking about, for those of you who work on parenting plans, my recommendation is to be including in your parenting plans statements that address firearm risks. Just agreeing to follow the law, the same way you have to have a driver's license or agree to make sure that the car seats are installed properly, make sure that any firearms that are in the home, because perhaps nobody is prohibited and the family maintains firearms, that they will be properly stored, locked, unloaded as legally required. You could have an agreement at the time of separation that neither party will maintain firearms in the home. I've worked on too many cases where people have separated, thought they agreed no firearms. Somebody ends up with someone who loves firearms, and now the kids are in an environment where there are more firearms than they ever thought they would see. Maybe that could have been dealt with at the time the agreement was developed. Follow all laws, follow all restraining orders. I've just been talking to some attorneys who are admitting that they're not always ensuring that their clients who are prohibited are following through on relinquishing their firearms. We've got to change that, and that neither parent will facilitate access to firearms. And then just 2 last things. Pierce's Pledge is an effort underway being spearheaded by Leslie Hugh, who is a mom who tragically, her son Pierce, 9 years old, was murdered by his father in San Francisco. shot with a firearm. This was not a case that was identified as a domestic violence case. Both parties were represented. It was considered what is referred to often as a high conflict family law case, which is a term that I think is very problematic and often obfuscates or distracts us from dealing with risks that would otherwise be perhaps better handled if it was identified as domestic violence case. But litigation abuse and other kinds of conflicts, another reason, mental health allegations or findings of concern, all reasons why when there's ongoing conflict, we have to think carefully about the presence of firearms. So Pierce's pledge is a request, a call for family law attorneys working in these kinds of cases to not be willing to have their clients maintain firearms so long as this kind of litigation is going on. So it's a call for a voluntary pledge to have those conversations, to have those firearms removed from the home while the litigation is happening. Again, not in cases where people are prohibited, because that should be happening legally anyway, but in cases where there would be a voluntary kind of relinquishment to reduce risk for everybody involved in the case. Lastly, we advocated for what has resulted in a $40 million allocation of state budget funds in California to fund implementation of SB 320, which we covered today, and other civil firearm relinquishment requirements. That is out for applications right now. Courts, this is through the Judicial Council, courts, DAs in some counties, law enforcement are working together to put these proposals in. $40 million, 36 to be allocated because some of the money is going for an evaluation and for administration and so forth. But I just really wanted to highlight this because your county may be involved, should be involved. And we are, of course, very excited to see the good work that will come out of that funding. And so let me just say now, maybe there's some questions, comments, reactions. I am here for it all. Thank you so much for your attention. I know it's a lot of heavy information, but I really appreciate it. So thank you, and would love to continue the dialogue.
Great. Thank you, Julia. Do you want to stop sharing so that maybe we could see some faces? But while we do that, I do actually have like one quick follow-up procedure question. So you mentioned AFS, Automated Firearms System. You also mentioned APS, Armed Prohibited System. So if you could talk about the relationship between the two, and then who has access to those systems to find out who has firearms.
Sure. Okay. So as you said, AFS, Automated Firearms System, in California, it's essentially referred to as a type of registry. So when you legally own firearms, they have serial numbers, and they are, we want to know who owns them. You might kind of think of it like who owns what VIN for your car, right? So you should be registering those firearms through, and that would be done through the Department of Justice. You fill out the appropriate form, and then the Automated Firearms System, which is available to courts and law enforcement, not to private parties. You can't go and look up who's in the Automated Firearms System. It's a DOJ record. You can see who owns firearms. There's nothing problematic about that list in the sense that these are people who legally own firearms. Then we have a prohibited persons database, because when you become prohibited, if you do the right thing, not what happened in Sutherland Springs, but you do the right thing because you're law enforcement in the courts, and your job is to enter that information into the CLETS, California Law Enforcement Telecommunication System. You enter that information in, the code identifies you or that person as a restrained party. You're a restrained party, a prohibited person. Maybe you're a convicted party. You're prohibited from having firearms. The computer system basically then pings or checks AFS and checks the it checks the prohibited person system and spits out a new database, a new list that's called APPS, Armed Prohibited Persons System. So it's APPS, Armed Prohibited Persons System. This is all run under DOJ. APPS is the one with 23,000 people who are listed as having firearms. So at some point they bought them. Maybe they did it 20 years ago and they're in there. And then in 2021, they were convicted of domestic violence or otherwise became prohibited. Now they're one of the 23,000 people. If you relinquished your firearm in 24 hours and provided proof to the court within 48 hours, you would no longer be in apps. You would never enter into apps because you might be armed. You would still be in AFS because you might own the firearm, but you're not going to be in apps because you've complied, right? So you've now indicated that AFS needs to be updated to show that you transferred, relinquished, or stored. So you won't be pinged and end up in apps. Doesn't mean you're not prohibited, right? It just means that you are not armed and prohibited because you complied with the AFS piece of it. Okay. So all of that information is only available to those who have access to CLETs. So that's law enforcement, prosecutors, courts, Department of Justice. Okay.
And probation.
Probation, right. And I think of law enforcement, probation, right? So those are the folks who can, and every year in around March, you can look up, the DOJ provides a report, a legislative report on apps. And every year their recommendation, almost every year, has been, we need to deal with this at the local level, that within that 48 hours, within that short time frame between the time someone becomes prohibited and they're required to provide proof, that's where we need to deal with this. By the time it gets into apps, by the time DOJ is sending out people, like in the Orange County situation, we have delayed that separation for far too long. So all of us around the country are trying to reduce the time between when someone becomes prohibited in a domestic violence case and compliance occurs. That's the key around implementation in this area.
Great, thank you. And Priscilla mentioned that the link to Julia's material is not quite working, so we'll work on that after this seminar and send you another link. I'm gonna ask Sylvia to unmute yourself and ask your question.
It's more like a comment. I had a civil harassment case not too long ago with the tenant because he was stalking me, and the judge did mention to him that he was not allowed to own a gun. And but I did notice that the judge read the statement, you know, regarding what you were saying, that maybe the other judge didn't. This one, as I observed, is like, because he read it, you know, the judge made up his mind immediately. That's all. Thank you.
Thank you for reporting that, right? So that's exactly, I mean, in all fairness, we need people to be told. We have some evidence that people aren't even told sometimes that they're prohibited. So it makes it harder for them to comply, obviously, and it may subject them to future criminal penalties. But more importantly, it means that they might not be separated from their firearm and could combine that harassment or abuse with easy access to firearms. And, you know, I'm not naive. I know that people can pick up illegal or unserialized firearms, ghost guns, those are parts that are manufactured or purchased, and then guns are built. That is also a problem, and we spend a lot of time working on that as well. But at least if we could get some of this low-hanging fruit, I think we can reduce risk in many different ways.
If there's any other question, I think Priscilla, you asked a question in the chat box earlier, but I think Julia answered your question. But Priscilla, if you want to unmute yourself, if there's any follow-up question you have, I think her question was, how can someone make sure that firearms are in the system? So I think Julia, you talked about the automated firearm system when someone purchases a gun, and then as well as APPS. But that private citizens don't have access to it. Yeah, Priscilla, go ahead.
My question was, she said when they're prohibited from buying one, you know how sometimes they forget to put it in the system. My question was, how can someone, let's say the victim, make sure that that person you know, they are put in the system because I know she mentioned earlier a situation, a case where it wasn't in there and they purchased it. So that was my question.
That's a great question. And I think that, you know, this is going to sound inadequate from a systemic perspective, but I'd say it may require having a conversation with the court if they become prohibited through the court process. If there's an advocate or a way to be checking in with the clerk's office to say, we want to make sure that this CLETS order, that's the CLETS form that you fill out, that the CLETS cover sheet that goes with the domestic violence restraining order processes, is designed to be entered either by the court, if they're what's called an entry court, or by law enforcement, because some courts turn it over to law enforcement. So systemically understanding what is, you know, sort of mapping out in your jurisdiction, how do prohibitions get entered? Is it the court? Is it the sheriff's office? When do they get entered? Should be within 1 business day. And mapping that out and understanding it, that systemically is important. And then on an individual case basis, it may require some advocacy. And if you get really stuck, it may require contacting DOJ to see if you can get some more information about what has happened in the case. They cannot reveal that information due to privacy concerns, but if there's a real concern that something hasn't been entered for some reason, then it may require some additional advocacy, like sending the CLETS form somewhere. You know, I don't even know what all the answers would be, because we have to assume and do what we can to support our systems following through on what they are required to do. And in my experience, most people are doing what they are required to do, but you may want to just map it and make sure that it is happening in a way that makes sense in your jurisdiction.
Thank you, Julia.
Thank you, Julia. Actually, we are working on that right now in Contra Costa County. So we're gonna have one more question, and then I have a really important announcement to make. So Kirsten, go ahead.
Yes, thank you for this webinar. I was following up on your on this recent shooting with the department that this individual was 19 and he's apparently getting the guilty death penalty. Can you provide your input as to, when it comes to young adults, when they're dealing with delayed development and insanity, can you explain, I'm sure this is a systemic issue, I guess, countrywide, and also all the shootings seem to be copycats. Can you provide some information on that as to what you think is lacking, or in the courts or in the families, like the structure?
I don't know if there's a brief answer to that question, Julia.
Right.
And I thank you for your comment, by the way. And then I think we do have one more question from Emily that I want to get in there before Julia responds. Go ahead, Emily.
Hi, Julia. I work with, I'm a lawyer who works with people who get civil restraining orders, and I frequently hear that law enforcement won't enforce restraining orders. I even had a client who was told by police that their restraining order didn't exist when it did exist. Do you have suggestions for working with law enforcement to make sure that they enforce restraining orders, including gun violence, restraining order provisions related to guns?
I have a lot of suggestions. I'm aware of time. Those suggestions include, you know, individual advocacy in particular cases, and then systemic pressure that can be applied in a variety of ways through behind the scenes meetings, political pressure, investigative journalism, utilizing the press, having a carrot and stick approach, funding pilot programs, figuring out what is most motivating for people. Are you trying to get reelected? Do you need more money? Are you afraid of being embarrassed? Do you care about headlines that suggest that you could have prevented a homicidal situation that resulted in the death of your own employees? Do you care about the public? You know, I would want to know more about what motivates folks. And then, and I would also be happy to work with you in particular situations. So you have my contact information. Let me know, because sometimes we are working in a variety of political scenarios, and give everyone, I've developed all sorts of tools, self-assessment tools, meetings, trainings, that are designed to persuade people to do the right thing. So happy to talk more about that. And with respect to the other question, it's a complicated issue. To some extent, we know that there are concerns about white supremacy, hate, and misogyny, some mental health concerns, although people with mental health diagnoses are more likely to be victims than perpetrators, so we can't blame it all on that. Easy access to firearms for people who are way too young to have that kind of access. Why did the 15-year-old yesterday in Raleigh have access to those firearms that apparently have killed at least 5 people? I haven't read the paper today, so I don't know if more have lost their lives. You know, attention being paid to violence and abuse, whether it's bullying, domestic violence, or other forms of violence in our country. So the combination of lack of access to certain services, not taking certain kinds of behaviors that are violent seriously, and how prevalent firearm ownership is, that combination is way too deadly for, I think, most of us. So and I'd say the vast majority of Americans support common sense gun laws that make our communities safer. So there is some hope there, and lots of efforts underway to try and change things. And I know that's not satisfactory when it hits close to home, or when any of us have to read about the tragedies in Florida and elsewhere. And I reference Florida just because of Parkland, not because of Florida generally. Okay, so anyway, if anyone wants to touch base, you have my contact information. I know we're a little bit over, so thank you, Susan. I know you have an important announcement, and I will sign off. So thank you all
No,
again.
wait, actually, this important announcement also involves Julia, because as you could see, Julia really has so much knowledge, information, and experience, and she's actually my shero. How about that? And she's going to come back to discuss policy issues surrounding the implementation of firearms relinquishment. So there's going to be another conversation. So today we learned about kind of the basic laws and framework and approaches around firearms and domestic violence. But the California Family Justice Network that I am part of is going to be hosting a policy conversation to really talk about how to implement these various laws in our local communities and share best practices. So Julia is going to be on the panel. It's going to be hosted by the California Family Justice Network on October 25th, 11 a.m. to around 12:45. We will send you a link to register for that conversation, because Julia will come back with her policy hat, and she's going to share the best way to implement various firearms relinquishment laws and rules that we discussed today. So we would welcome all of you to join us in our next conversation on October 25th, and we'll send you the link for registration. And again, thank you all for being here today. I know there was a lot of information, and some of you may feel like you need to unpack some of this. And here at the Family Justice Center, we are hosting more conversations to really discuss what's happening at the local level and how to work with our law enforcement partners. So you will hear from us. And if you have an interest in any of these topics, of course, you could always reach out to us here at the Family Justice Center. We'll be happy to include you in our future conversations. Again, thanks to Julia, like your role, really, you're my role model, Shiro, and really appreciate everything you've done. And your information today was just really excellent. Thank you.
Well, thank you. Thank you all.
Thanks to all of you for showing up today on Friday to learn together. Really appreciate all of you for being here. And hi to some of my friends that I haven't seen in a while. Yeah. And yes, everything is going to be emailed out to you so that you could watch it again, because there was a lot of information today. Bye, everyone. If Natalie was here, we would send you off with the music, but well, we can't do that today, but maybe next webinar, we'll have some music. Thanks, everyone. Bye. Bye, Julia. Thank you again.